Okay, now I want to welcome you all to this very comprehensive CLE program on mortgage foreclosures and remind you all that this session is being recorded. I just want to, before we start, remind you of some other upcoming CLE programs that the Rockland County Bar Association is offering. Next week, we have a program on jury selection with the Commissioner of Jurors. And other upcoming ones, we have one on estate planning, on matrimonial bankruptcy in April. In May, we have CPLR and special juvenile immigration status, and one on workers' comp. So, keep an eye out on for your emails, look on the webpage. We have a lot of programs going on. I am going to be giving you 4 codes during the program. Please write down the codes and send them in on the attendance sheet along with your evaluation. I need both the evaluation and the attendance sheet with the correct codes in order to give you CLE for this program. And again, please mute yourself. And now I will turn it over to Ron DiCaprio for additional introductions.
All right, very good. Good evening, everybody. We've got a 3-hour program for you tonight. If you've been here before, you understand how comprehensive the program is. It's got a very fast-moving agenda. If you loaded your documents from the link, you'll notice in the second slide the agenda for tonight's meeting. So there's a lot going on tonight, and your 3 hours will go pretty quickly. The program is being taped. It will be available to the Bar Association for about another 6 months after tonight, and then it will get taken down because of the changes in the law and the continuing complexities that we're facing, which is why the panel named the program tonight Continuing Complexities and Some New Stuff. Barbara told you about the 4 codes and the evaluations. There are 4 speakers. They've been with us year in and year out. I'm going to just give you very brief introductions. You know all of them already. We have Senior Associate Justice of the Appellate Division, 2nd Judicial Department. Mark Dillon is with us again. So he'll give us that view from the top tonight. And as you all know, he's been on the bench at the Appellate Division since 2005 and actually began his justice career in 1988. Second in the panel is David Evans Marcus. David has been with the court system, beginning with the New York State Court of Appeals in 2001. He now is a judicial referee in the 9th Judicial District. And he's not only going to be one of our panelists tonight on some of the topics, he'll be running all of the slides for us tonight. So that's David. And then the 2 people who are going to battle the point and counterpoint tonight. Okay, that's Suzanne Berger. She's up here on my screen, at least on the top right in blue. She is a commercial litigator and presently of counsel to Bryan Cave, Layton, and Paisner on the Avenue of the Americas in New York City. She regularly represents mortgage loan servicers in the commercial and residential lending industry and supervises teams of lawyers with regard to the litigations. She's handled many foreclosure cases at the trial level, the Appellate Division, and before the Court of Appeals, and has also been in the West New York Practice Series, a contributing author to the General Practice in New York portion chapter on mortgage foreclosure. And then we've got Derek Tarson. He will be representing the consumer side in the counterpoint to Suzanne tonight. Derek, of course, you all know, is the Foreclosure Project Director and Deputy Director of the Civil Division of the Legal Aid Society right here in New City and Rockland County. He's been with the organization for 14 years. It's his 11th year on this panel. He speaks statewide on mortgage foreclosure issues. He is a co-chair of the CLE program sponsored by the New York State Bar Association on mortgage foreclosure and workouts. So we welcome all four of these really esteemed. I've got papers on their resumes here. I'm giving you just the beginning because we've got a tight calendar. All very esteemed panelists tonight. It's 6:05 p.m. We promised to get you started, so we'll move right into the first topic with Suzanne.
Actually, I think that's me. So I am Derek Tarson. Good evening, everyone. So Suzanne and I will be doing this together. We will be talking about the Foreclosure Abuse Prevention Act, which was almost entirely what our program was last year, because it was new legislation and we wanted to go through it. So now now it's been in effect for a year, and we're just going to be talking about the new issues that have arisen. But as by way of review, the Foreclosure Abuse Prevention Act was passed at the end of 2022 with the purpose to thwart and eliminate abusive and unlawful litigation tactics, and basically to curtail the statute of limitations so that lenders would not be able to reset the limitations period as often as they had been doing. And it applies to all actions commenced on an instrument described under CPLR 2213-4, which is basically a note in a mortgage, in which a final judgment of foreclosure and sale had not been enforced, really meaning that there has been no foreclosure sale of the property. Next slide, please. So the highlights of the legislation were that, and the biggest one is at the top, that no party may unilaterally revoke or reset accrual of a cause of action or otherwise extend the statute of limitations. Because what had been happening was that the lenders would send notices of deacceleration, or would simply discontinue an action, and under the Court of Appeals decision in Engel in 2021, that was sufficient to start the whole statute of clock again running. So no party may unilaterally revoke or reset. And the second bullet point, that a unilateral voluntary discontinuance does not reset the statute of limitations. The next one is a CPLR 205A, which now has a -A, which is only applicable to mortgage foreclosure actions, where the 6 months grace period to restart an action applies only to the original plaintiff unless the assignee pleads and proves that it acts on behalf of the original plaintiff. And that was to overrule the Second Department's supersede Itani decision, which allowed an assignee to be able to use the grace period. And the list of exemptions it used to be only that the grace period would not apply if there was a lack of personal jurisdiction or a failure to prosecute. But the list of being a failure to prosecute has been greatly expanded. The next one is CPLR 213-4. A plaintiff is stopped from asserting that a mortgage was not accelerated unless there's an express judicial determination on a timely interposed defense that the instrument was not accelerated. So if the previous action was dismissed for lack of standing, that would be an express judicial determination that the instrument was not accelerated. But a plaintiff now cannot say, oh, we lacked standing 10 years ago, but no one caught it, and so the loan was never accelerated. And then there are also changes to that's actually wrong. It's RPAPL 1301 and General Obligations Law 17105. We'll be talking about 1301 a little bit later in the program. Next slide. So the big issue this year has been whether the Foreclosure Abuse Prevention Act is retroactive, meaning that if a case was discontinued before FAPA was enacted, does that does that not reset the statute of limitations, or does it? And the right now, at this instant, on March 13th, 2024, that issue is settled because there's a First Department case, Genovese versus Nation Star, stating that FAPA clearly was intended by the legislature to apply retroactively, and examined it under this Court of Appeals decision, matter of Gleason. And absent a contrary determination by another appellate department, Genovese is binding on all trial courts. And I have the Second Department cite for that. And the Second Department itself has been applying FAPA retroactively for now. So until we have word that that changes, the FAPA was intended to apply retroactively. Next slide. I will hand it actually to Suzanne for this, because this is the Fannie Mae's position on
Right.
Yeah.
So Fannie Mae takes the position that the statute should not be applied retroactively, that it's unconstitutional to do that, or it's contrary to the legislative language and intent. So far, there really aren't cases to support that. There are some situations, though, where it is not retroactive. For example, if you have a federal plaintiff, the statute will not apply under the supremacy clauses. Fannie Mae, though, is not a federal plaintiff. Fannie Mae instead takes the position that the immediate effect language is not a clear expression of legislative intent that overrides traditional canons of statutory construction. I will say that the much of the dispute goes back to the application section, and Derek talked about that. I think that's 2 slides back, David. If you could retro, yeah, okay, thank you. No, 1 more back. Yeah, application. It applies to all actions commenced on an instrument described under 213(4) in which a final judgment of foreclosure and sale has not been enforced. So there's some question about whether, once you have a final judgment, whether or not it's been enforced, it becomes vested for constitutional purposes. And second, even after it's been enforced, we all know in the foreclosure context, often there are motions to set aside the judgment for lack of service, for other procedural infirmities. And if that motion were to be granted, does FAPA apply? So I'm sure we'll see some cases on that in the coming years, but it seems that that is a fertile area for a discussion on retroactivity. For now, the case law seems to be pretty uniform on a non-constitutional basis, that it is applied retroactively, that is, to existing cases where the judgment hasn't been enforced. Derek?
Yes. So next slide. So no appellate court has yet decided whether FAPA retroactivity would be unconstitutional. I actually would like to turn it over to Judge Dillon, because the Second Department does have a procedure with the appeals pending before it, based on orders that were entered before FAPA was enacted.
Sure, thank you, Derek. And I believe that the procedures that I'm about to discuss actually are used in the other departments. When FAPA came in December, 15 months ago, we didn't know exactly where all these issues were going to go. And we had decided that as a matter of policy and procedure, that we would apply the FAPA law to existing cases, with one exception. Let's put that exception aside for a moment. If we had an appeal come up, let's say, that involved an angle issue, And Engel said one thing when the matter was at the trial court, maybe at the and now FAPA comes in and changes the law. We were going to clearly apply the law as it existed at the time we'd be hearing and deciding the appeal. So there were some briefs, of course, that would be stale on these issues because the briefs were written before FAPA was enacted. But we made one exception to the application of FAPA and applying FAPA, and that was that if anyone were to argue that FAPA was unconstitutional, we thought that it would be inappropriate for us at the appellate level to be the court of first impression that would be handling that. We were getting requests from law firms that wanted to submit supplemental briefs or letter briefs on the issue of unconstitutionality or constitutionality, and kind of jump the shark to have the appellate division second department hear and decide those issues without there ever really being a trial level decision on those same issues. So as a matter of policy and procedure, we determined that where unconstitutionality were to be raised by a party, that we wouldn't touch that. We would instead decide the appeal based on the FAPA law, but we would specifically decline to decide any constitutionality requests that came our way without prejudice to an application being made at the trial part to raise those issues there. And the reason that we felt strong enough to carve out constitutionality from all the other issues of FAPA was because significantly, this is an issue that can affect a large number of cases in our department and beyond that throughout the state of New York. And ultimately, in my view and the view of others, this is an issue of such importance that it really should be decided one way or the other by the Court of Appeals. So in order for that to occur, we thought it would be best, in order for a trial court to be able to develop an entire record, research, let that record come up to an appellate division, let it then go to the Court of Appeals. But the second department, as you all know, is more backlogged than the other departments. So I would imagine that by the time this gets to the Court of Appeals, it probably would be from a case or cases that arise from one of the other three departments.
Thank you. Yeah, that's very, very interesting, and it means that we will be talking about this for several years to come.
Yes.
So with the trial level cases, this, as this slide indicates, there is a slight majority that of cases that have held that the application of FAPA retroactively is not unconstitutional, but there are some that have held the other way. And here in Rockland County, the courts are about split. Next slide, please. So the arguments that for it are basically centered around FAPA being violative of the due process clause, the contracts clause, and the takings clause. There's one lender has argued that FAPA is a bill of attainder to punish foreclosure plaintiffs. I don't think that's going anywhere. But in order for any of those arguments to be valid, FAPA has to impair substantive vested rights. Next slide. So little levity here, and if one thing that you remember is the slide with Jackie Gleason's face on it, and you might remember that Gleason versus Gleason, which was his divorce case in 1970 before the Court of Appeals, gave the Court of Appeals the opportunity to define vested rights. The next slide. And in Gleason versus Gleason, the issue was the divorce reform law, which for the first time in 200 years allowed divorce on grounds other than adultery, including a formal separation decree or judgment after 2 years of living apart. And Mrs. Gleason had obtained a separation decree in 1954 and said that retroactivity of the divorce reform law would be unconstitutional because her rights as a married person for Social Security and pension rights, inheritance rights, and a right in the marital status itself were vested rights and protected by the Due Process Clause and the Equal Protection Guarantee. Next slide. But the Court of Appeals disagreed and said that a vested right is an immediate fixed right of present or future enjoyment. And marital rights were inchoate and contingent and may be taken away by legislation before they vest. And therefore, the state could take away the rights to Social Security or pension benefits by legislation. Next slide. So applying Gleason's reasoning here to the FAPA, the right to commence a foreclosure action is not a vested right because the statute of limitations has really not shortened. And there is a First Department case which held otherwise where the statute of limitations for non-medical malpractice had been shortened. But FAPA only requires dismissals of cases that were colloquially second bites at the apple, and second bites are not vested rights. And the case I cite there, Mealy from Westchester County, basically says that, but doesn't use the term second bites. It uses much more formal language. But however, as Suzanne mentioned briefly before, there is a possibility that a plaintiff would have a vested right in a judgment of foreclosure that cannot be appealed. Next slide. And Suzanne, do you want to talk about, you talked about briefly, do you want to talk about any of these cases?
Oh, wait a minute. No, I think they're just examples of the post-judgment, how courts discuss retroactivity in a post-judgment context for reference.
Okay. So next slide. So with regard to the particular arguments for constitutionality, due process, if there's no substantive right, then all that needs to be proved is a rational basis. And the memorandum in support, the legislative memorandum in support, does state it's to prevent lenders and loan services from manipulating the statute of limitations and abusing the judicial foreclosure process, and to ensure equal application of state laws to all litigants currently in foreclosure actions. One thing that's not here is something I found very persuasive, which is until FAPA, mortgage foreclosures were unique because no one could claim in a personal injury action that, oh, you know, I really wasn't injured 3 years ago and I have the right to reset the statute of limitations. So the idea of resetting the statute of limitations was quite unusual, and FAPA really restores it to other civil actions.
Well,
with regard to the contract
but just
clause,
to be clear, that's because mortgages are payable in installments. So you're really talking about acceleration and deacceleration, not a change in the approval.
fair enough. Fair enough. The contract clause, there is and never was a contractual provision to allow the lenders to unilaterally reset the statute of limitations. As Suzanne just said, what it does is it allows unilateral acceleration. Very few mortgage contracts allow unilateral deacceleration. There may be one or two, but in any case, the issue always was this implication that deacceleration meant a reset of the statute of limitations, and FAPA changes that. And with takings clause, there's no property right impaired by FAPA to implicate the takings clause. So next slide.
I'm going to just interrupt you for a moment here, just to give you the first code. All right, the first code is the word mortgage, MORTGAGE. The first code is the word mortgage. Be sure to write that down on your attendance affirmation. Thank you.
And so last year, we had mentioned 3 cases where the constitutionality of FAPA was under review. So we just thought we'd give you an update. And it's really a split verdict because the one in Eastern District is still pending, I believe, a decision from the Second Circuit. The City Mortgage versus Delisle found that retroactive application of FAPA was not unconstitutional, but New Res versus Kalina in Albany County went the other way. Next slide.
So if everyone is very certain of the procedural posture of our big question, is FAPA retroactivity constitutional? We're going to complicate it just a little bit. Judge Dillon had suggested that because the second department tends to be a busier department, that the issues of retroactivity and constitutionality might reach the Court of Appeals from another department before the second. But it turns out there's another possibility. There are two cases arising out of the Eastern District that have, at the trial level, determined the various constitutional issues. East Fork concerning the contract clause, Article 13 versus Ponce de Leon Federal Bank concerning the due process clause, where appeals have been lodged in the Second Circuit. The appeals have been perfected. And in one case, East Fork, oral argument already was held on February 29th. Now, if you are one of the four presenters listening to that oral argument, you can actually click in your materials and listen to it. Is the best podcast in town. But we really do recommend that you consider listening to it for a couple of reasons. One of them is that you'll hear the Second Circuit spending about 75 minutes on the details of the contract clause argument. The other concerns procedure, because though the first department in the Genovese case made clear that FAPA is retroactive, and the second department has kind of gone along with it, albeit not with a lot of analysis, one of the questions the Second Circuit was sitting with, and we'll hear what their decision is shortly, is whether the retroactivity of FAPA is so settled as a matter of state law that the Second Circuit can deem itself bound. One of the things they considered instead, and they might yet do it, is to certify that question directly to the New York Court of Appeals and let them determine the statutory question once and for all. Is FAPA retroactive? They could decide that it is, confirm that it is based on Genovese and how the second department has been going, or they can certify it. If they certify it to the Court of Appeals, the Court of Appeals answers that question of law and plugs that answer back into the Second Circuit. Assuming without deciding that it's determined to be retroactive, then the Second Circuit has a subsequent question. Do they decide the contract clause issue based on a sufficient record, or do they remand it back to district court for fuller treatment? Or they just decide it, in which case this could be set up to go up to the United States Supreme Court on the constitutional question. We mentioned this because this is hot. This is happening right now. Oral argument was just 2 weeks ago. And so this is going to probably be the first case out of the dock to figure out how clear it is as to retroactivity, and at least as to the contract clause question, which way the winds are blowing as to the constitutionality of retroactivity, assuming that retroactivity is in fact the way that the federal and the New York Court of Appeals will be construing the statute. All of this is to say, stay tuned. When we had Kessler, when Suzanne succeeded in her appeal in the Kessler matter, there was a small cottage industry of motions to re-argue and renew, especially renew in light of the Court of Appeals decision in Kessler. And then, of course, FAPA came along. So watch carefully. I'm sure this is going to be a hot issue in the coming months, perhaps the coming years, and we will stay tuned with you and report back.
All right, and on that, we've got to move to our next topic, which is RPAPL 1301, and I think that's Suzanne.
It is. So 1301 has existed for probably almost 100 years now. A new section was added by FAPA. And so it is still the single action rule, but the new section 4 says in the event that such action, meaning the foreclosure action, is commenced without leave of court, the former action shall be deemed discontinued upon the commencement of the other action, unless prior to the entry of final judgment in such other action, a defendant raises the failure to comply with this condition precedent therein, or seeks dismissal thereof based on a ground set forth in CPLR 3211A4. So Section 3 had always required leave of court to commence or maintain another action to recover any part of the mortgage debt while a mortgage foreclosure action was pending or after final judgment for the plaintiff in the prior foreclosure action. But now you have this deemed dismissal provision. Next slide, please. So subdivision 3 clarifies that requirement for leave includes situations when a second foreclosure action is commenced. Procurement of such leave shall be a condition precedent to the commencement of such action, and failure to procure such leave shall be a defense to such other action. So just if you think about this for a minute, you have to get leave to discontinue the first action before you start a second action. And when you have a statute of limitations approaching, you have to do your 90-day notice. As a case Derek will speak about later, I think it's in Derek's materials, you can't do that while another action is pending. So it might be tight to discontinue that first action, which for whatever reason was commenced by the wrong plaintiff or had some other defect that you need to discontinue. Let's move to the next slide, please. So in this case is out of Putnam County. It's a slip opinion, and in some sense it doesn't change the law, but or rather it's not necessarily an example of the new law, but the new law sort of reawakened this theory in many people, and so you started seeing defenses about other actions pending. In the Wilmington Savings Bank case, the Lau, the first action pending was a quiet title action. The mortgage hadn't been recorded in Putnam County through a defunct title company's error, and so an action was commenced in connection with this reverse mortgage to record the mortgage before a foreclosure could be commenced. And so that was ongoing and disputed. And meanwhile, foreclosure counsel commenced a foreclosure action on an unrecorded mortgage. And then it quickly realized that was an error and it was discontinued by stipulation. But counsel for the heirs in the quiet title action said, oh, because you brought that other action, the new amendments to 1301 required dismissal of the former action, deemed dismissal. And the court said, no, 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 these are not two foreclosure actions. No dismissal is required, and noted in dicta that in any event, the foreclosure action, by the time the court got around to hearing the motion, had been voluntarily discontinued. So it's an issue I think you will see more because we have many situations where actions pop up, not necessarily seriatim, but at the same time. So just be on the lookout for that if it's an appropriate defense. The next slide raises the question of whether dependency of a prior action is an affirmative defense that must be raised in the defendant's answer. And this court in Kings County says the defense that there is another action between the same parties is waived if not raised in a pre-answer motion to dismiss or as an affirmative defense. As such, the defendant who raised the question for the first time post-answer can no longer seek dismissal on that basis. And it could have been raised earlier, even though FAPA did not exist, because it still would have been a defense under old 1301 in this case. If I had a bet, we'll be talking about this again next year with a different result. I mean, in a different case, because as we know, the law has been changing so that most of these defenses and foreclosures, like the propriety of a 1304 notice or others, can be raised at any time. But right now, we have this case out of Kings County that says it's an affirmative defense that must be raised. Derek? Oh,
Yeah, I don't have
Sorry,
anything
Mark.
to that.
I'm sorry, Mark.
Okay. So before we spend any attention on, we're changing topics, and we're talking about part of the new FAPA law, which is CPLR 205-A. But before we get bogged down in the particulars of this particular section, let me give a little bit of background. The CPLR has always had a CPLR section 205 sub A, the A in parenthesis. That is separate from and continues to exist, but separate from this new FAPA statute, which is 205-A. So when we're talking about 205-A, we have to be very careful whether it's sub A under the incumbent law or whether it's dash A under FAPA. 205-A under FAPA amends the application of the incumbent version of 205 sub A. So I want to talk just for a minute about 205 sub A, out of which this statute grows. 205 sub A is that statute that provides the plaintiff with a 6-month window to recommence a case, even if the statute of limitations has already run on that case, if the case has been dismissed, but there are some circumstances under which the case cannot be restarted or recommenced if the dismissal is for certain grounds. So under 205 sub A, which is not the one on your screen, if there are 4 grounds where a party, whether in a residential mortgage foreclosure case or any kind of case, cannot commence the action again after dismissal within 6 months. The first is voluntary discontinuance. The second is failure to obtain personal jurisdiction over the defendant. That would normally apply to a situation where service of processes is not performed properly. It can also apply to a lack of long-arm jurisdiction over the defendant, but for purposes of residential mortgage foreclosure, we're really talking here about service of process in probably the bulk of the cases, if not all of them. A third circumstance where the 6-month window does not apply is where, and I'm quoting from the statute, a dismissal of the complaint for neglect to prosecute, close quote. Now, neglect to prosecute can have different meanings under different statutes, but the case law has interpreted that to refer to CPLR 3216, which is the section which permits the court or a defendant to serve a 90-day notice upon a party for failure to prosecute, directing that the prosecution be resumed and a note of issue be filed within that 90-day period. And as we know from that statute, if the note of issue isn't filed within 90 days, then a basis exists for the filing of a motion to dismiss the case. So if a case is then dismissed by that motion, there is no 6-month window for the recommencement of the action. And the final circumstance where the 6-month window is not open is when there is a final judgment. And that makes perfect sense, because if action number 1 results in a final judgment, there should be no action number 2 for, if for no other reason, for res judicata. So FAPA comes online and it grows out of 205 sub A. The 205-A is what is now on the screen. And what this new law says, and it only applies to residential mortgage foreclosures, is it takes the 4 exceptions that we just discussed, where you don't have the availability of that 6-month window for recommencing the action, but it adds a number of other circumstances where if the case is dismissed for one of those reasons, the 6-month window is also shut. So it's a stricter law on the lenders than what the general law is outside the scope of residential mortgage foreclosures. So under the FAPA version of this concept, there is no 6-month window open if an action is dismissed for failure to comply with CPLR 3126, which is if your complaint gets stricken for, discovery failures or other reasons. Also 3215 sub C, we know, provides that if you don't take a default judgment within a year from when the defendant's answer is due, the court shall dismiss the action, unless some good cause is shown for not doing so. So if you have a case that's dismissed for not timely seeking a default, then you don't get the 6-month window. 3404 is another provision of this law where you don't get the 6-month window. That's for post note of issue cases. If, for instance, the bank doesn't show up for trial, the case can be marked off the calendar and ultimately dismissed. Another circumstance where there's no 6-month window, and again, this is only in the area of residential mortgage foreclosures, if there's a violation of a court order or a scheduling order or a violation of court rules or the failure to submit a timely order or judgment. The list here is almost as comprehensive as could possibly be imagined, where if the lender fails to do something which results in a dismissal of the action, they are no longer entitled, as other plaintiffs would be, to the 6-month window for reviving an action. So the effect of this probably is that it might force the lenders in these residential mortgage foreclosures to be much more attentive to their cases and much more careful in how they prosecute them. The types of circumstances where the 6-month window might be available is probably very difficult to imagine. We might be able to come up with one or two. And I'll just to round out the discussion, under 205-A, Derek had mentioned that the plaintiff, the original plaintiff, can of course use this, but if there's an assignee, then you have to prove that the assignee, to take advantage of this 6-month window, has to prove that they're acting on behalf of the plaintiff. And the statute also provides, finally, that if it is used once by a party, an action is recommenced, you only get one bite at that apple. There's no such restriction under the incumbent law. So you can't have successor plaintiffs with cases dismissed and each of them invoking the benefits of a recommencement of the action within the 6-month period.
Okay, then with that, if Judge Dillon, you are concluded, we're going to move on to the next section, which is the tolling of the limitations period during COVID.
Yep.
All right, so we've got Judge Dillon, and then we've got Derek and David on this part.
Yeah, we're going to take it ever so slightly out of order. So we need to do a little bit of time travel, friends. If FATBA is retroactive, then it means that some of the difficulties and complexities that arose during the pandemic, remember when the courts were functionally closed and there were emergency orders governing the limitations of time and litigation, we're going to need to revisit those, because if FAPA is retroactive, then we're going to see more cases in which the statute of limitations continue to run, notwithstanding the voluntary discontinuance of an action, for example, continue to run during the pandemic emergency. And that means we're going to need to pick up a doctrine that was laid down in the Second Department called Brash v. Richards. And in Brash v. Richards, the question arose, is the 228-day period during which the governor's emergency orders functionally stopped litigation and stopped the continued clocking of time for cases, was that a toll or was that a suspension? If it was a suspension, then anything that needed to be done during those 228 days needed to be done when the 228 days expired. That would be on November 3rd of 2020. If it was a toll, then it's like taking a bite out of time. And those 228 days would be added to whatever period would then continue after the 228 days. And so the second department picks this up, and it's really interesting because Brash v. Richards itself doesn't tell you what the case is about. It doesn't matter what the case is about. It's this abstruse procedural question. And Brash determined that it's a toll rather than a suspension. And so you get your 228 extra days for whatever time might be clocked, whether it's the statute of limitations or time for service or some other litigation time that was ordered by a statute or by a court. You get those times back. You get the extra 228 days. Now, Brash wasn't the end of that discussion. It was merely the beginning, but it brought forward a sleeper of a case that Derek is going to tell you about now, because it now bears on how we're going to do this calculation of time if FAPA is retroactive.
Thanks. So, yeah, this is a sleeper case we didn't report in previous years, and we really kind of passed by. It's called Lubanti versus U.S. Bank from 2019, and we have to start with what the statute says. The statute about tolls and how it affects the statute of limitations is that the statute of limitations tolled where the commencement, and I've underlined that word, of an action has been stayed by a court or by statutory prohibition. So the question in Lubanti is, when a debtor or defendant files a bankruptcy petition, does this toll also affect the pendency of the action? So in Lubanti, the facts were unbelievable, but and there were several bankruptcy petitions, but some of the bankruptcy petition filings happened while a foreclosure case was pending, and the defendant argued, well, that the bankruptcy case did not stay the statute of limitations because it did not prevent the commencement of an action. And the Court of Appeals held 6-1, but the dissent is very interesting, that the CPLR 204A toll applied regardless of whether commencement was stayed or not. But it also hinged largely on the fact that the filing of the bankruptcy petition was within the control of the debtor. And the dissent stated that the majority simply read the word commencement out of the statute. So there's still a pending question. Does Lubanti apply to COVID-19 tolling where it's not in the control of anyone? It's a worldwide pandemic that happened to everyone, and only time will tell whether Lubanti will be extended to COVID-19 stays.
Judge Dillon.
So we now have one other case that is a qualification of the Brash case that David was talking about. The Cuomo COVID tolls, we know they actually started on March 20 of 2020. And as David had mentioned, they expired on November 3rd of 2020. That's 228 days. The Ruiz versus Sanchez case is a twist on this, because in Ruiz, the statute of limitations would have expired in its normal course 76 days after the Cuomo orders went into effect, meaning that there was another 152 days to November 3rd, 2020, which were beyond when the statute would have expired in its normal course. Nothing prevented any plaintiffs from commencing actions by e-filing or whoever during these periods of time. The toll simply extended the time for parties that needed it. And in this particular action, the plaintiff commenced the lawsuit by adding the 228 days of the total Cuomo tolling period from November 3rd, when the tolls were lifted, and commenced an action on April 19th of the following year, 2021. Ultimately, when the case came to appeal, the appellate division decided in the second department that that action was untimely because the plaintiff was not entitled to a full 220-day tolling period. Instead, because the statute of limitations expired in the middle portion of the Cuomo periods, you're only entitled to a toll for the number of days between when the statute of limitations would have expired in the normal course and November 3rd of 2020. So the plaintiff here, instead of getting 228 days from November 3rd, only was entitled to 152. When you take November 3rd and you add 152, the action needed to be commenced by April 4th. Instead, it was commenced on April 19th, and the plaintiff was out of luck. So the moral of the story here, aside from the fact that what God giveth, God can take away, is that you got to be very, very careful of how Brash operates in the event that the statute of limitations would have run in its normal course during the time frame of these tolls.
Thank you, Judge Dillon. Why are we telling you any of this? It has to do with FAPA retroactivity requiring time travel. Because FAPA operates to retroactively nullify the deaccelerative effect of certain things, we now end up having to calculate the timeliness of actions based partly on what was happening during the pandemic. So here's an actual case with a very slight twist on the facts. There's a borrower loan default alleged in September of 2014, and a first action is commenced in 2015. For whatever reason, the action lingered for some time. Maybe it was a bankruptcy, maybe there was a death. You never know. These things are quite common in this field. And the first emergency order is issued for the pandemic in March of 2020. The courts functionally shut down. There's your 228-day period. The courts are functionally reopened in November of 2020. The 228 days are over. People are starting to come in for those old conferences under the Emergency Eviction and Foreclosure Prevention Act hearings. And in this action, it's voluntarily discontinued in 2021, figuring, okay, no problem, we can now recommence the action. Something was wrong, let's just go ahead, clean it up and start over. No fuss, no bother. We can discontinue the case, and under the case law as existed at the time, that had the effect of deaccelerating the acceleration that had been put into effect by commencing action number 1 and calling the entire mortgage amount due. So action number 2 is commenced on November 29 of 2021. All is well until FAPA is enacted in December of 2022. It's deemed effective immediately. Very shortly thereafter, the first department determines that it's to be applied retroactively. There's your Genovese case. And now defendant comes and makes a motion to dismiss the action as untimely, arguing that under FAPA, the voluntary discontinuance of the first action did not reset the limitation period. So this is Brash v. Richards on steroids mixed with FAPA. So let's see what happens. FAPA being retroactive, we apply CPLR 3217E. No longer does the commencement of an action and then the discontinuance reset the statute of limitations. So based on this timeline, the statute of limitations began to run with the first acceleration brought by the first action, notwithstanding the discontinuation, even though the lender or the servicer had relied on the case law then existing where it could recommence, no fuss, no bother. FAPA upended that, and we count the statute of limitations back from the first action's commencement date, July 24 of 2015. Now, that being so, the limitations period would be done 6 years later. That would be July of 2021. And the second action having been commenced after that, plaintiff would be out of the box. And you couldn't cure it by saying, all right, we're only going to look for the last 6 years of installment payments because of another provision of FAPA that is under CPLR 213 sub 4, as I believe Suzanne was talking about, where any part of the loan is deemed to be untimely for collection, plaintiff cannot claim otherwise. Plaintiff is stopped from denying the untimeliness if defendant pleads that any part of the loan is untimely, unless there's been a judicial finding to the contrary. In this instance, there was a voluntary discontinuance. The court had not determined anything. And so therefore, it would appear that these two provisions of FAPA, CPLR 3217E and CPLR 213 sub 4, would put plaintiff out of the box. Now put brash in. If you count the statute of limitations as having begun to run with the first action's commencement in July of 2015, when the courts shut down in March of 2020, there was still 1 year and 124 days left on the statute of limitations, which means that there wasn't going to be a Ruiz issue that Judge Dillon was talking about, where the limitations period would lapse in the middle of the closure. So they get the 228 days, add the 228 days to the end of this. Second action was commenced 1 year and 26 days after the 228-day time had expired. Therefore, action number 2 was timely. Brash v. Richards saved the second action. This is confusing. This requires something that attorneys are not often good at, and that is math. So because of FAPA's retroactivity, be careful. Look at the effect of the tolls and any exceptions to the tolls. Apply Brash, apply Labonte, apply Ruiz, and try not to think about whether the legislature intended any of this. This is the law as it now stands. If the Court of Appeals or the Second Circuit determine otherwise as to retroactivity, you can forget we taught you this. But the law is the law as it now stands. And so therefore, because we're now looking retroactively to what was going on a few years ago, expect a lot of these cases. And therefore, expect a bunch of law to percolate through it.
All right, that said, then we're going to move on to our next topic, which is interest tolling. And we're going to hand this over to Judge Dillon.
You know, several years ago, if you do a Westlaw research, and I have, the number of cases out there where there has been an equitable tolling of interest was extremely rare. I think it is fair to say that now it still doesn't happen very often, but it happens more than it used to. And when it does happen, it seems as if there's a great uptick in seeing it in the area of residential mortgage foreclosure cases. And we all know how long these cases can sometimes languish in the courts. There's 5 cases to talk about here. The first 3 of them, we'll call it the trilogy. They're all Deutsche Bank cases, Armstrong being the first. Armstrong involved an action that was commenced but then dismissed for lack of prosecution. And then a second action was commenced 5 years later. This, of course, under the law at the time that would have allowed that. And in that second action, there was a referee's report. There was a motion to confirm. And the defendant, in response to the motion to confirm, sought to toll the interest that had been accruing between the time of the first action and the commencement of the section action. That's like a 5-year period of time. The Supreme Court had denied that tolling, but the Second Department reversed it and tolled the interest during that period of time. It did so in noting that the reason the first action was dismissed, it wasn't a discontinuance like we often see. It was a dismissal for lack of prosecution, which shows some wrongdoing of sorts on behalf of the plaintiff. The bank also failed to offer an explanation for the 5-year delay, and on that basis, determined that a tolling of the interest for that 5-year period was appropriate. Now, there's a lot of cases that might have a large gap between action number 1 and action number 2. But I think the lesson to be learned from this case is that if the first action is dismissed as opposed to being discontinued, but dismissed for some type of laxity on the part of the lender, then that places the lender into some jeopardy if then a long period of time follows before the second action is commenced. The lesson to the homeowners is to make the motion to toll the interest in these cases. You know, you have interest that's statutory, but you also might have the interest defined by the contract term. But over a long enough period of time and the amount of money involved, that interest can truly add up. The second Deutsche Bank case is the Gonzalez case. All of these cases are from 2023, incidentally. And it's a circumstance where the homeowner had made a cross motion to toll interest as a result of a 19-month delay in the handling of the case, during which time the case had lied kind of fallow. The second department in that case felt that tolling was not appropriate because there was nothing particularly egregious about 9 months as compared with 5 years in the Armstrong case that we just discussed. And there was no particular wrongdoing on the part of the bank. The word that really jumps out at me, at least, on this Gonzalez case is the finding that there was nothing egregious. It sort of says, without actually saying, that there's an egregiousness standard that should be met by the defendant in the event that equitable tolling is to be granted by the court. And perhaps an egregious standard makes sense because interest is usually a right, whether it's contractual or statutory, and you're not going to take that right away easily unless there is some showing, a real serious showing, such as an egregious standard or something sufficiently compelling to warrant that relief. The third Deutsch case is the Kumba case, and in that instance, you had an action that was commenced in 2008, and then 10 years later, in 2018, there was a motion for a default. Now, there must have been some taking of proceedings by the plaintiff bank during that first year because there was no CPLR 3215C problem that would require the court to have dismissed the case for not timely seeking a default. But in year 10 of this litigation, the defendant moved for a toll of the interest, and that was denied. And the interesting language by the appellate division in denying the tolling of interest in that case is that there was no showing on the papers that were before the appellate division, the record, that the lender had engaged in any lengthy or unexplained delays in the prosecution of its case as would warrant the relief of an equitable toll. So it might have just been one of those cases where, despite the 10-year time frame that elapsed, things were being done, and then things were being done, and then some more things were being done, and we do see cases that kick around for lengthy periods of time in this subject matter. Lesson to the defendant: the defendant has the burden of proof. Absolutely, you got to point to the record as to the showing as to why equitable tolling is appropriate. And turning our attention now to U.S. Bank versus Zapata. Zapata involved a proposed intervenor who had an interest in the property that was the subject of a foreclosure case. And this case had been pending for many years. And in year 10, that is when the proposed intervenor made the motion to intervene in the case. Now, we all know from a reading of CPLR 1012 that parties can intervene as a matter of right if they can show that they are affected by the outcome of the case, but it has to be by timely motion. When the intervention motion came in, the party not only sought to intervene in the case, but also sought to toll the interest that had been accruing during the 10-year period prior to that motion. The court granted it. The appellate division modified it, well, actually reversed it. And the reason they did so was that language that I just mentioned, that if you're going to intervene in a case, you have to do so upon timely motion. The appellate division felt that the long period of time that existed here before that motion was made was not timely. And therefore, if the intervention falls, the equitable tolling that had been granted to that party must fall as well. So the lesson is that for intervening parties, you want to make that timely motion. And the final case on equitable tolling from the Second Department in 2023 is U.S. Bank versus Roberts. We had an action commenced against against three parties, two of whom appeared, one of whom defaulted. There was a motion for summary judgment as to the parties that appeared and for a default as to the party that didn't. The court granted that application, but directed that the lender settle in order. And as we know, in the uniform rules, there's a provision that you're supposed to settle in order within 60 days. If you don't, the action can be dismissed unless there's a showing of good cause as to why you haven't abandoned. Well, not the action is dismissed, but the underlying motion is dismissed, unless you can show good cause as to why you did not timely settle the order. So 2 years go by without any settled order in this case. The party that had defaulted moves to vacate the default. And eventually a conference is scheduled with the court, and the lender fails to appear at the conference. And it's at that time that the court dismisses the action under Uniform 202.27 for the lender's failure to appear at the conference. The bank later succeeds in its motion to vacate the default and the dismissal, but the court, using its equitable authority, imposes as a condition of the vacatur an equitable tolling of interest. So an application is made by the defendants to the appellate division seeking reversal of the portion of that order which had vacated the default. There was no motion, no appeal or cross appeal that had anything to do with the equitable tolling of interest. In the opposition papers by the bank, it had mentioned that the tolling of interest was in error, but there was no cross appeal on the part of that bank. So the appellate division ended up affirming the vacatur of the default against the bank, but nothing could be done as to the equitable tolling of the interest because there was never any notice of appeal or any perfected appeal by the bank on that issue. So the lesson here is that you have to make sure that your notice of appeal gets in and then you follow through with a perfected appeal if you want to have your equitable tolling issues heard by the appellate division. And I think we've gotten through our 5 cases.
All right. With that said, we're going to move on to the next segment, which is evidentiary considerations. We'll turn this over to Suzanne Berger and Derek Tarson again.
Let me just take this opportunity in between sessions to give you another code. The second code is interest, INTEREST. The second code is interest. Okay.
Does
Now
that
we're
mean
done with
anyone who
interest.
puts an S at the end of that will not get credit?
Get extra credit.
Extra credit.
There you go. There you go. I was going to say it depends on my mood, but
Right.
Retroactively.
right.
Told for next year. Okay.
Yeah.
Right.
Evidentiary considerations.
This is a topic we've touched on in past years, but we included it again this year as a reminder because for reasons that are unclear, parties tend to forget that the evidence of a business record is the record itself, and the affidavit is the foundation to admit that record. An affidavit which has a foundation about the preparation of a record and then says, I looked at the record and this is what it says, is not sufficient. One needs the record itself. And that is, we were reminded of that by the Second Department in 2019 in Bank of New York Mellon v. Gordon. And despite it being 4 years, or I guess more now, we still see over and over again affidavits which purport to contain evidence. And I'm sure the appellate division sees lots of those because the cases, started before Gordon. But we need to remember that. And the slide has the Gordon case, and then it has a more recent reminder from the Second Department that it is the business record itself and not the affidavit that serves as the proof of the matter asserted. So, next slide, please. One of the situations that you see that a lot is the proof of default, where the servicer puts in an affidavit that says the loan hasn't been paid for 10 years. I looked at the ledger and that's what it says. And even though everybody knows it hasn't been paid for 10 years and there's no dispute about that, the borrower doesn't claim to have paid, the lender in its summary judgment motion still needs to make a prima facie case. And that means you need the business record. So it means you need the account payment history or whatever it is that the servicer uses to look at to know whether payment has been made. And the case in the slide, Citibank v. Potente, is an example of that, where the court said, as a general rule, the mere filing of papers received from other entities, even if they are retained in the regular course of business, is insufficient to qualify the documents. Because what happens in these cases is the default started with servicer 1, and we're now on servicer 3. And so how are you going to use documents which were the business records of servicer 1? Well, you can do that by having an affidavit from servicer 1, and then an affidavit from servicer 2, and an affidavit from servicer 3. Or you can have an affidavit from servicer 3 talking about how the prior servicer's records were incorporated into your records and used and you routinely relied on for your purposes. In the example I just gave, it gets a little tricky because you might know that to be the case. The affiant might know that to be the case with how servicer 3 incorporated servicer 2's records, but query whether there's sufficient evidentiary basis about servicer number 1. The point is, you need to think about the evidence in each element of your case, whether it's the predicate notices, standing, or evidence of default. Next slide, please. This is another example of a case where the affiant said that she was, the records were incorporated into the recipient's own records, but she did not establish that by sufficient facts. Buzzwords don't work for this purpose. Next slide. Derek, is this yours?
Uh,
Or is it
yes,
mine?
I'm sorry, this is mine,
Okay.
yeah. So I'm actually going to, we're running a little bit behind, so I'm going to just go through the next two slides really fast. The hearsay question comes up very often when servicers have to prove that they mailed the 90-day notices under RPAPL 1304. And they often do use these third-party vendors, the most common of which is Covius, which used to be known as Waltz. It's misspelled on the top one. It's WALZ. And if they are not familiar with Waltz's mailing practices and the records were not incorporated or routinely relied on their business, that's not sufficient. But go to the next slide. So under but, which is the top case here, this is where they did it right, and they had the affiant. They bolstered the servicer testimony by using third-party software into which Waltz entered information, and the servicer got the information, and that constituted a standard office procedure. So these cases are helpful to determine whether you can challenge, as a defense attorney, whether you can challenge whether there's proof that the RPAPL 1304 notice was sent or not, and it depends on how detailed the affidavit is about describing the integration between the third-party vendor and the servicer. Next slide. Okay, and we're going on to the next section. Okay.
All right, we're on to notary, the updates in the notary law. This is Judge Dillon.
So, about a year ago, a little over a year ago, the notary law was amended. It's Executive Law 135-C, and it's an amendment that we now have as an outgrowth from the technological changes that we saw as a result of the COVID virus. The law that is now on the books is that you can have documents executed with a notary public, where the notary is virtual and at a different location than the signatory who is virtual. The requirements of the statute are that the notary must first register with the state of New York and file documents certifying that he or she is capable of using virtual technology for these procedures. At a notarization event that is virtual, the notary must confirm the identity of the person executing the documents, just as if it was an in-person confirmation. You can hold up a driver's license to the camera or other means of confirmation. The notary must also specifically confirm that the copy of the document that the notary has is identical to the copy of the document or the document that the signatory has. And that can be accomplished, of course, by having the signatory hold it up to the camera for comparison. The oath is then given virtually. The witness must be observed by the notary signing the document. And the notary signature is then e-signed onto the document that the signatory party has. In other words, the official document is the one that's at the signatory end, not the document that's at the notary public's end. The signature isn't just a name of the notary and the notary information that goes with it. There must be an additional statement indicating that this was a signature that has been applied electronically. We know that the affidavits usually have wording to the effect that on such and such a date, personally appeared before me, so-and-so. The term personally appeared is under this law deemed satisfied if the requirements of this new notary law are followed. If the document that is signed needs to be recorded, then a copy of that signed document will suffice. But in addition to the e-signed notarized document, there must be an additional certificate attached to it. It's a certificate provided by the notary confirming that all of the procedures of Executive Law 135-C has been filed in connection with the execution of that document. So where does that leave a provision, another provision? It's in the CPLR 2309C. 2309C is the section of the law that provides that if you have a witness execute a document outside the state of New York and then use that document, let's say, as an affidavit in connection with a motion or as for other evidentiary value, that the affidavit has to be accompanied by a certificate of conformity. And it's not unusual in residential mortgage foreclosure cases sometimes for some bank officer to be out of state. This is an area of law that has always confounded attorneys. It's a bit of a pain in the neck to comply with. But the purpose of the certificate of conformity is to assure that the notarization and execution of the document out of state complied with either the notary procedures of the state of New York or the notarization procedures of that foreign state. And the certificate is supposed to be attached to an affidavit in order for that affidavit to be considered in an evidentiary sense by New York courts. It seems to me that if you now have virtual notarizations where the notary is in one place and the signatory is in the other, you can have a New York notary and an out-of-state witness, and there is no longer any need under that scenario to have a certificate of conformity. Why? Because you have a New York notary overseeing the execution of the document. Now, does this mean that CPLR 2309C and its requirement for certificates of conformity is now complete dead wood in our CPLR? I wouldn't go that far, because maybe there are still some circumstances where, for whatever reason, somebody gets an affidavit and has it notarized out of state and not using the virtual procedure. So that if that's the case, then you still need to have your certificate of notarization. One caveat as well with this notary law is that you are not allowed to use it if the person executing the document is outside of the country. They can be out of state, but they can't be outside of the country. They can be outside of the country in one circumstance, and that is when the document being executed has to do with real property that is located in the state of New York. So to the extent that the notary procedures have been made more convenient, particularly if the witness is out of state, I think that this is good for the bar and for notary publics. And the less use of CPLR 2309C, the better. The parting will not be without such sweet sorrow. The last thing that I'm going to mention that is of a technological nature is Technology Law 304, Subdivision 2. It says, in relevant part, an electronic signature may be used by a person in lieu of a signature affixed by hand. The use of an electronic signature shall have the same validity and effect as the use of a signature affixed by hand. We now may be living in the days of George Jetson in light of this. You really see technology law in the area of contract execution. We may in our own lives have had circumstances where we've been sent a document to our email, a contract, and if we assent to the terms, we can e-sign it or check off a box that we are agreeing to all of the terms. And those signatures will be binding. We know that in the GOL, sections like 5-701, there are certain contracts that must be in writing and signed by the party to be enforceable. In consideration of marriage, contracts that can't be performed within a year, and others. But under the technology law now, we can have these documents signed and they will meet the requirements of the GOL. The real intent here behind the law has to do with the execution of contracts. I took a minute to see whether or not technology law 304 was ever utilized in the sense of executing affidavits or affirmations. I haven't seen a single case, and I wouldn't recommend, just in case, that anybody use this law to e-sign anything that you plan to file with a court in affidavit or affirmation form. The last thing that I'll mention here is to be careful with technology law 304 subdivision 2. There is a case from the from Supreme Court New York County, which was very interesting. Zintex, Zinntex. I have the citation here somewhere, where a contract was sent electronically to a signatory who, instead of applying a alphabetic name on the signature line, instead used an emoji. And the question was whether or not the emoji was sufficient evidence of an intent to be bound. And the court said, under the circumstances of that case, no. It wasn't the handshake emoji. I think it might have been the happy face, but we can get into a discussion. Maybe we certainly don't have the time to decide what emojis might be sufficient under the law and which emojis might not. Counsel your clients to stay away from those. I'm done.
Okay, very good. We're going to move on to Derek. Derek, you got 4 minutes, and I think you have 3 slides.
Okay, except that we have a breaking news here. So I'm gonna, if it's all right, I'm gonna talk about the breaking news before the break, and then we'll start with the 3 slides, which I'll go through very fast after the break.
All right,
So
breaking news.
Breaking news is that yesterday, there was an announcement of a settlement between the New York Civil Liberties Union and the Office of Court Administration with regard to CPLR 3408B, and this was reported in the New York Law Journal. 3408B, it's one of those statutes you don't hear about a lot, and what it says in relevant part is, at the initial mandatory settlement conference, any defendant currently appearing pro se shall be deemed to have made a motion to proceed as a poor person, and the court will determine whether such permission shall be granted. And if the court appoints counsel, it shall adjourn the conference to a date certain for appearance of counsel and settlement discussions. And what was happening was that this statute was being ignored in Kings County. So the New York Civil Liberties Union brought a class action, and the settlement agreement basically holds that in Kings County, going back, anyone who's had a conference who appeared unrepresented at a foreclosure settlement conference after December 1st of 2022 has a chance for a do-over of their settlement conferences if they were not appointed counsel, or if the court did not consider their appearance as being an application for the appointment of counsel. The settlement agreement only applies to Kings County, but it is likely that, but there is language in the settlement agreement that does apply to the Office of Court Administration prospectively statewide, and it is possible that this will hit other counties. In Rockland County, I'm glad to say that the Legal Aid Society of Rockland County does appear at all settlement conferences, and if someone appears unrepresented, we will represent them as long as we don't have a conflict and as long as they want us to. So I think that the number of homeowners that this will affect in Rockland County are very low, but it will probably affect people in other counties. Anyone want to add anything in the minute that we have remaining? Okay.
All right, you did that real quick. All right, we'll just take our break right here. We will be back at 7:45.
Thank you.
everybody who's out there. All right, 7:45, we are on to the loss mitigation portion of the program. Derek, you're up.
Okay. Well, I know this is a shock to everyone, but interest rates have gone way up in the last few years. So this has caused a problem with borrowers who are trying to get loan modifications. And they are it's sometimes 3 or 4 percentage points higher than it had been. And it also is causing a problem because many servicers use what's called a payment reduction rule, which means that if a borrower tries to get a loan modification and they apply a higher interest rate, that would result in a higher principal and interest payment, and it's an automatic denial. So if you represent borrowers, you can request a waiver of the payment reduction rule, but you generally need proof of the borrower's changed circumstances. Next slide. And knowing the loan type is important. So VA loans and FHA loan modifications require application of the market interest rate. You can tell which one is an FHA loan because it says FHA case number on the face of the mortgage. VA loans are harder to spot, but many times they'll use the term veteran. The veterans situation is really horrible. It's thank you for your service, and now we're going to take away your home. But fortunately, someone is up there kind of realizing that this problem exists. And there is this new VASP program, which will roll out soon where below market interest rates will be available. The problem is no one knows when. It's supposed to roll out around the end of May, but we're not quite sure. Some COVID-19 recovery modifications also offer low rates that are lower than market. Next slide. However, if you cannot get an interest rate that's lower than market, and so in other words, you had a interest rate that was 4%, and now the lowest that you can get is 7.375% or something like that. You may want to consider a Chapter 13 bankruptcy, which allows you to cure and maintain, where the delinquency, if the delinquency, particularly if the delinquency is low, maybe 30,000, 40,000 in that neighborhood, that can be spread out over a 5-year bankruptcy plan, and the borrower might have enough to pay their ongoing mortgage. And when they finish the bankruptcy plan, they still have the same interest rate that they had before. Just note that the mortgage must be paid while the plan is being confirmed, or the plan may be denied. Thank you, and I think we can go on to standing.
Okay, hi everybody, part 2. Standing is a topic we address every year, and it had become a little routine since the Court of Appeals told us that as long as you attach a copy of the mortgage to the complaint and it's payable to the holder or to the plaintiff, and you've asserted standing unless the defendant can come up with some evidence to the contrary. But that's true for a standard mortgage, which is based on a negotiable debt instrument. If the instrument is not negotiable, you can't be a holder of a non-negotiable instrument. So you have to be the owner. And so the pleading and proof that is associated with a non-negotiable instrument is different. You'll note, of course, that in many reverse mortgage complaints, the pleading is that the plaintiff is the holder or the owner and holder or something like that. And then the question arises, is this a negotiable instrument? If the instrument is not a negotiable instrument, you have to show, among other things, that you obtained it. The plaintiff has to show that it obtained it for value. And as a practical matter, that's virtually impossible in this context because they're usually purchased as part of a package, part of a bulk loan sale, and the purchasers and sellers are not going to want to part with those documents to show that they paid whatever discount they paid on the par value of those loans. And so your client will not allow you to prove that there was value received for them. We know that at least in the second department, a cash account agreement, which is common in reverse mortgages, is not a negotiable instrument. However, not every reverse mortgage uses a cash account agreement. So the mere fact that you are litigating over a reverse mortgage does not mean that you have a non-negotiable instrument. You need to look at the agreement itself. Next slide, please. Article 3 governs negotiable instruments, and so Article 3 sets out what makes an instrument negotiable. An instrument must be signed by the maker or drawer. It must contain an unconditional promise or order to pay a sum certain in money, which may include interests and cost of collection, and no other promise, order, obligation, or power given by the maker or drawer, except as authorized in the article. And this one and the next one must be payable on demand or at a definite time are the problems with the reverse mortgage cash account agreement, because most of them are payable not on demand or at a definite time, but upon the death of the borrower or the spouse of a borrower, which usually is not a definite time. It's unknown.
I would just like to add, though, Suzanne, that the other issue here is the pay a sum certain.
Yes.
Yeah. So, I think we get onto that. So okay.
Yeah. Yeah. Actually, can you? There are other issues. Two other issues. One is the sum certain, because these are basically advances. The notice for a maximum sum and advances are made or not as it goes along, and so it's not a sum certain that's due on the face of the note. And also, some of them have been found not to have unconditional promises to pay. The promises are conditioned on, say, the additional promise to pay taxes, real estate taxes, as you go along, or something like that. So those are the issues that may make an instrument non-negotiable that crop up in these reverse mortgage cash account agreements. Next slide. One West Bank versus FMCDH Realty is the second department case that presented the question of whether the cash account agreement was a negotiable instrument. Because in that case, the plaintiff asserted in its complaint that it received the original cash account agreement and it was endorsed in blank and it had it in its possession at the time it commenced the action. Therefore, it was a holder. The problem was, if it was not a negotiable instrument, you can't be a holder under Article 3. And this cash account agreement was signed by the borrower, and it contained an unconditional promise to pay, but, next slide, it had significant provisions that made it non-negotiable. As Derek pointed out, it was an open-end revolving line of credit with a promise to pay all amounts advanced, which were unknown from the face of the document and at the time of origination. This particular cash account agreement allowed for the periodic adjustment of the advance limit, and also it was not payable at a definite time because it was payable on the borrower's death or the borrower's failure to pay taxes, or if the borrower no longer occupied the property for an extended period of time. So for all those reasons, the cash account agreement was not a negotiable instrument under Article 3-104. And because it was not negotiable, the second department held that the plaintiff cannot establish its standing by demonstrating that it possessed the original note, cash account agreement endorsed in blank at the time the action commenced. Next slide. So what is a poor plaintiff to do? Well, a case from Rockland County, Bank of New York Mellon Trust v. Hendrickson lays out one possible route, and that's under UCC Article 9-203B. Next slide. There's a long list of things the plaintiff can prove. One, that value has been given. Two, that the debtor has rights in the collateral or the power to transfer rights to a secured party, and then one of the following. And you can take a moment to read all these things, but let's say it's not really practical to prove this. So the best thing to do is, if you have a negotiable instrument, is to make sure you have the right plaintiff. Because if you have a non-negotiable instrument. If you have a non-negotiable instrument, it should be payable to the plaintiff. So you need a specific endorsement to the plaintiff, and then you'd be fine, because we don't have a holder problem. Or, next slide.
Well, actually, Susanna, before you leave Hendrickson, because that was my
Sure.
case. So
Go ahead.
I represented the borrower in Bank of New York Mellon Trust versus Hendrickson. And if you could go to the next slide, which yeah. So the issue in Hendrickson was that the plaintiff had only proved that the non-negotiable note was endorsed, which is not an assignment. So through discovery, I established that they had no assignments of the note, and it's 3A here that actually causes the most problem. It's that the term debtor is a little bit misleading, but it's that the owner of the note must provide a description of the collateral being assigned. First of all, it's got to be assigned, which was the problem in Hendrickson, and that if it is assigned, it's got to be specifically described. I don't believe a specific endorsement is enough, because it's an endorsement, it's not an assignment. But I suppose that's up for debate.
Right. Well, I think if you have a specific assignment, you might, and you don't have the other problems, you might come back onto Article 3 too.
Okay.
And if you have a definite time and so forth. But yes, that will be the next year's case.
That's
So
right.
the next slide is another example of a case that found, this is from Florida, but it's another example of a case that found a non-negotiable instrument in the reverse mortgage context, because the promise to pay was governed by another writing, the loan agreement, and it was not for a fixed amount, because the borrower had no personal liability and lender could enforce its rights under the note through the sale of the property only, and we didn't know what the value of the property was. So there you go, no definite amount under Florida law. Next slide. So here's some tips. If you have a power of attorney from the plaintiff, from the owner to the plaintiff that predates the commencement, perhaps you will have standing as the agent for the owner. Again, it's not a holder situation, but an agent can commence an action, a foreclosure action. Transfer the foreclosure from the owner to the plaintiff, and the plaintiff, right, well, that's what I just said. And you will have to establish the complete chain of title in this case, from the originator to the plaintiff. And the use of the specific endorsement, there is this old Indiana case that talks about that. So Derek, we'll see if that stands up.
Yeah, so it's a 1916 Indiana case, and we don't know whether that'll hold up in New York.
It's the best we got at the moment.
Okay.
Okay.
I would just like to add that we've been talking about reverse mortgages, and that's probably the most definite situation where this arises. But the same argument does even apply to home equity lines of credit.
I agree with that. Yes.
Yeah, because in those cases, it's there's money being borrowed, there's being money paid back, and it is a cash account. Go ahead.
Yes. And that has for years sort of not been, it sort of slipped by until the reverse mortgage cases came to the front, I think. So, all right, anyway, it doesn't apply to all reverse mortgages, as we said before. You have to examine the debt instrument, and CIT Bank v. Morgan would be an example there. I think that's it for that section, and now we move on, I think, to Kessler. Is that right?
I would just before we leave it, I would just say I'm happy to talk if you're representing the borrowers and you're dealing with a situation where you believe that this issue exists. I'm happy to talk to you about Hendrickson and about my experience with this. I got a call from an attorney on Long Island just on Friday about this. So just putting it out there. Thanks. All right, Suzanne, go ahead.
And are you aware of any cases that have made the proof under Article 9?
No, I'm not aware of any proofs. But Hendrickson is the only one because FDMCH only sent it back to the Supreme Court to review on summary judgment. I believe Hendrickson is the only one which actually dismissed a foreclosure case based on the fact that they had not transferred a non-negotiable note correctly.
Okay. So Kessler we talked about last year because last year, about 13 months ago, this Court of Appeals decided Bank of America v. Kessler, reversing the Second Department, and found that the form of 1304 notice in the record and used by many banks was acceptable because it contained all the required language, and the additional notices that were included on a separate page were not misleading. There was if you're in bankruptcy, there's special rules that apply. There was a notice to service members, and there was a Fair Debt Collection Practices Act notice, and those were held to be okay. So 1304 notices have to be sent separately from notices of a different kind. And so now we have litigation about whether other kinds of notices or enclosures are misleading such that the 1304 notice doesn't meet the Kessler test. Next slide. So the next two or three slides are examples of post-Kessler cases that talk about the communications that were sent by the servicer. And in this particular case out of the Southern District, this additional information which says it's an attempt to collect a debt, and if you're in bankruptcy, the notice is not intended as an attempt to collect a debt. Those were in Kessler, and this phrase, and this company has a security interest in the property and will exercise its rights against the property. That wasn't discussed by the Court of Appeals in Kessler, but the Southern District said that was okay, that was not misleading, and it was related to the subject at hand. Next slide. In Bank of America v. Gonzalez, this notice was also approved. This notice contained additional information on a separate page. It was titled Important Disclosures, and it had short paragraphs on a lot of topics: verbal inquiries and complaints, important bankruptcy notice, credit reporting, mini Miranda, HUD counselor information, Equal Credit Opportunity Act notice, the SCRA disclosure, military personnel service members, and notices of error and information, and then lastly, a sub-paragraph on qualified written requests. The next page listed the collection agency's license numbers with the New York City Department of Consumer Affairs for the city of Buffalo and the city of Yonkers, and concluded another notice for New York residents regarding filing complaints with the New York State Department of Financial Services. In other words, it purported to give borrowers their rights under many, many federal, state, and local laws. And the Second Department said that was okay. That was neither misleading nor confusing. Next. This one too was approved. This one had additional information on the third and fourth pages. And the different notice here said if a creditor or debt collector receives a money judgment against you in court, state and federal laws may prevent the following types of income from being taken to pay the debt. And then it lists all the exceptions from garnishment. And the court said that's okay, that's not misleading, and it's not, and it is related. Now, we move to the next slide. Here's some more cases. The additional information in Wells Fargo Bank v. Smith consisted of accurate statements that further the underlying statutory purpose. And in Santander Bank v. Spitzer, the notices contained additional information about plaintiff's status as a debt collector and debtor's rights in bankruptcy, and that was okay as well. So now we have a question under Kessler whether if both spouses' names are on the 1304 notice and both spouses are not necessarily borrowers under the loan documents, although they're required under Second Department 1304 law to receive the 90-day notice, whether that is false or misleading. In Suffolk County, the court said no, but they qualified the no by saying, well, neither spouse said they were actually confused by receiving this notice. And what the court specifically said was neither spouse, quote, exclaimed that because the 1304 notice was addressed to both rather than each, that caused them to pause in reaching out to the lender to avoid foreclosure. But you could picture a case where spouses could claim confusion because of some fact that was unknown to the lender, like they were divorced and the divorce decree gave one the responsibility to pay and not the other, or something. I also cite the Harper case down below as another example of a notice that was upheld. We had discussed this case last year. The court had asked for additional briefing when we met last year to determine whether the mini Miranda was misleading, and then decided no after the Camberdella decision. Next slide, please.
Suzanne, I just wanted to, the Weber case does not discuss Yapkowitz, right? And I don't think, I just think it was not raised, but I do want to make mention that there is a Second Department case that says that when both the spouses' names are on the 1304 notice, that is not compliant with the statute.
But both spouses must receive it.
Right.
So, yeah, you're right. But I don't know if that's confusing to invalidate the contents of the notice.
No, I think it's not, but I just wanted to make there's a separate issue. I just wanted to make that clear.
Okay. And this case, Derek, is yours, the next one.
Yes.
So the fall case, you want to talk about it?
Sure. So yeah, this was a case where my client had been in a foreclosure action, and the plaintiff realized that there was a Kessler problem, and sent a 90-day notice while my client was in settlement conferences, and then moved to discontinue. And I made the argument, and the court agreed that the RPA-LP, the whole purpose of the RPA-PL 1304 notice is to permit a borrower to get help before litigation or outside of litigation, and the court agreed that to permit service of said notices while a foreclosure action is pending would circumvent the statute and negate its purpose. So it's only a trial court decision for right now. Who knows what the appellate court would do, but that could be helpful.
This is sort of interesting because we always told our clients there's no prohibition on doing this, and if you're running up against the limitations period, you may as well get it out to avoid that problem, right? But we'll see, because there's no prohibition in the statute against this.
That's right. There is no prohibition in the statute. It's more of the legislative purpose.
Right. Well, query whether you need to be actually confused. Anyway,
Well, that's not a Kessler issue, though. And that has nothing to do with confusion. That just simply is if you're sending 1304 notice and you're already in litigation. Well, I suppose maybe you do have to prove confusion. Okay, I think it's wrong. Sure. Okay, we'll see.
all right. So we'll talk about that, I'm sure, next year. And then this is just a final note. Last year, there were attempts made to legislatively abrogate Kessler. In other words, to amend 1304 to say the statutory language and only the statutory language should be in the 1304 notice. For the reasons set forth by this Senate sponsor, they thought additional verbiage would blunt the impact or dilute the impact of the notice if there was all this extraneous right language about other rights borrowers might have. But neither the Senate bill nor the Assembly bill passed last year. I do understand that the Senate bill is kicking around this year, although it's been amended so as to make pretty clear it's not retroactive. It would only apply to notices going forward if it were to pass. There are other legislative amendments, being discussed this year as well. So we'll have to keep an eye on them and see if they pass. Another one having to do with 1304 is the lender would have to establish it had standing at the time it sent out the 1304 notice. How and it would do that is not entirely clear. Whether it'd have to attach the note or other proof or just prove it later on remains to be seen, but we'll worry about that if that amendment is enacted. Okay, next slide.
This is me.
Yes.
Okay, so this is one of the things that Kessler did, aside from the whole deceptive notice thing, is that there were a lot of procedural wrinkles because cases were either discontinued or dismissed due to Kessler. And I'm not going to talk about discontinuances for right now, but if a case was dismissed, there is case law that says that if an appeal is not brought and the time to appeal has expired, a motion to renew an order of a judgment of dismissal cannot lie because due to a change in the law, because there has to be finality somewhere. And there's this fourth department case, Red Eye, and also Glicksman versus Board of Education. And we mentioned that last year. But foreclosure plaintiffs, and I've run into this with several cases now, have tried to circumvent this rule under these two second department cases that are in the 306B context, which hold that a complaint is not dismissed until there's a judgment of dismissal rather than just an order. So next slide. Rubin and Braun both addressed 306B, where the court had dismissed a complaint because of a failure to serve the parties within 120 days. And after the dismissal, the plaintiffs brought a motion to extend the time for service. And the courts held that that motion could be entertained in the interstitial time between entry of the order dismissing the complaint and the judgment of the dismissal. The judgment is only entered by the clerk and is a ministerial act. So Rubin and Braun did not expressly state they were limited to 306B, but every case they cited had to do with that statute. However, several appellate courts have held that a final judgment is not necessary where there's an order of dismissal, but not a judgment of dismissal. And there's this one case, a Second Department case from 2007, Daniels versus Miller L. Industries, one from the Third Department this year, and First Department, which are cited there. So next slide.
Do you
Oh.
mind, David, Derek, if I just jump in for a second on Ruben?
Sure.
I wrote Ruben. I'm sorry. I wrote Ruben, not Braun. And the theory, it was a case where a defendant moved to vacate a default. And part of the argument was that there was improper service of process. And the court dismissed on the lack of proper process. And it was then after that order, but before the entry of a judgment, that the motion was made by the lender for a 306B extension of the time to, in this case, reserve process. And the theory behind Ruben and Braun is that once you have an order, that does not dispose of a case. Orders can be re-argued. Even the judgment process, you can have litigation over legal fees, over what the interest should be, et cetera. And so we felt that, at least in this context, as you pointed out, that the case is not final until the entry of the judgment.
Yeah. And I will say both Ruben and Braun, the fact pattern was pretty egregious, and there was a statute of limitations issue. So you know what they say about hard cases. So however, I am very glad that we do have these three other appellate cases outside of the 306B context. Okay.
Great. I'm going to interrupt for a moment, just again to give the third code. So the third code here is challenge. It's the word challenge. The third code is challenge. Back to you.
So David, this is you.
Yep. So special heads up for those of us that maybe have clients in residential foreclosures in Ulster County, the bottom of the Third Department. This issue concerning Rule 20227 dismissals goes to the question of what can a court do compatibly with the uniform rules to bring foreclosure plaintiffs along in making their motions. And the operative rule is in pink on the screen. At any scheduled call of a calendar or at any conference, if all parties do not appear and proceed or announce their readiness to proceed immediately or subject to the engagement of counsel, the judge may note the default on the record and enter an order as follows, and sub A provides if plaintiff appears but defendant does not, the judge may grant judgment by default or order an inquest. And on the flip side, if the defendant appears and plaintiff does not, dismiss the case. So the question arose, if plaintiff doesn't make a motion as required by a prior order of the court, say make your motion for judgment of foreclosure and sale by date certain, what may the court do, if anything? Now, the Rockman case in 2021, which we've covered in the past, construed Rule 20227 to say that the readiness to proceed includes compliance with an order to bring a motion. And so therefore, if a plaintiff doesn't bring that motion compliant with the court's directive to do so, the court may enter 20227 relief and dismiss the case. Of course, the Second Department giveth, the Second Department taketh away. This last year in 2023, the Second Department overruled Rockman and said in the Gonzalez case, no, 20227 really does speak to appearance, not proceeding by means other than appearance. So if you don't show up, that's one thing. If you show up but you haven't filed your motion, that's another. And so the Gonzalez case said, you may not, court, dismiss the action just because plaintiff didn't bring a motion. Doesn't matter how egregious, doesn't matter how many times, you may not do this compatibly with Rule 20227. Now, what does this have to do with Ulster County? The Third Department pretty much takes the position that Rockman got it right and Gonzalez got it wrong. They construe Rule 20227, this is the third department now, to say what the chief administrative judge is doing in these uniform rules is regulating the hearing of causes and calendar practice generally. And it cites CPLR 3401 for this proposition. And on that reading of the intent behind this, and there's some constitutional matters about the chief administrative judge's power to promulgate rules of practice consistent with the statutes, and there's no statute saying you can't. Therefore, what this is really about is the chief administrative judge saying, move your case along, or else, as a matter of calendar practice, we can throw your case out. What this means is that in Rockland and Orange County, if the referee, like me, or the court says to a plaintiff, you haven't filed your motion, I'm going to kick your case out, that doesn't work in Rockland and Orange County, but it does in Ulster. There is now a department split. Whether the Court of Appeals will take this up going forward, we don't know. But there's a sleeper issue in this to be aware of. Because think back to 205-A of the CPLR, the 6-month saving statute added by FAPA. One of the exclusions from the 6-month saving clause, bless you, iPhone Bill. One of the things that is excluded is failure to proceed consistent with a rule of the court. So if in the third department, plaintiff's case is thrown out because plaintiff failed to act, failed to move in the manner that the court required, that dismissal would be an exemption from the saving statute, and plaintiff would not be able to recommence within the 6 months compatibly with 205-A. That isn't an issue in the second department because you can't dismiss the case. This doesn't touch the court's power to toll interest nunc pro tunc. So if a plaintiff is being dilatory in bringing a motion, the court can say, well, it would be inequitable to let plaintiff profit by its failure to proceed, and so we're going to toll interest. And now we have to apply everything about tolling interest that Judge Dillon and Derek were talking about earlier. This is going to be another one of those, we'll get back to you on it. The best way to address this, if you're a plaintiff, is to make your motions timely. If you have had an action dismissed on grounds of Rachman, what does this mean for being able to renew and vacate the dismissal on Gonzalez grounds? We're going to need to leave that to you for the reasons that Judge Dillon talked about earlier. So another one of those stay tunes. I believe the last matter is post-judgment interest.
All
And
right,
then we'll
well,
try a hypothetical.
Before we get to post-judgment interest, I haven't seen anybody asking questions in the chat. So if there's anybody here watching the CLE and you have a question, put it in the chat so that we can get to it at the back end of the program. We're running just a bit quicker than timing. So I have a question for you, David. All right, since you used the language and it's in the slide, the last slide that you had. All right, at the bottom, you use the words nunc pro tunc, and it almost sounds to me as if the tolling of the interest under these circumstances is more and just an inequitable ruling in and of itself, not necessarily a nunc pro tunc ruling, because all rulings happen after the event occurred, not before the event occurred. So is it really nunc pro tunc in your mind, or is it just simply the court using its equitable powers to make something right?
Well, given that interest has been continuing to clock for X months, or we've seen cases where it's X years where plaintiff hasn't done what needed to be done, I would assert that an interest tolling remedy, dating, again, I'm going to use that word, retroactive to some time reasonable where plaintiff should have proceeded, would be nunc pro tunc. It may be angels dancing on the head of a pin, because if you're a plaintiff or a servicer, you don't care if the interest toll is nunc pro tunc or something else. It's an interest toll.
Right.
It's a loss of profit.
Anybody else in the group? Anything from the appellate division on that one? Nunc-pro-tunc itself as a
No.
remedy?
I'm going to avoid that one.
All right, very good. Okay, so then we will move on to our next topic, which is post-judgment interest. And this one goes to Judge Dillon and Suzanne and Derek.
Yeah, this is another one of those issues where, we say it every year. These issues pop up and we're going to have to get back to you because the courts are going to have to sort it all out and we'll know more at a future time. The provision of the CPLR that sets the rate of interest in New York, of course, is CPLR 5004, and that has been 9%. 9% has been the legal rate of interest now for going on 40 years. But it's not quite as favorable a rate now, I suppose, as it has been for most of the past few decades. But there was an amendment that was made in April of 2022, which qualifies the 9% rule. Prior to this amendment, 9% applied to all cases where interest was to be awarded across the board. The amendment in 2022 provided that in the event that a debt were to result in a judgment on a consumer credit transaction, that the interest that would be applied post-judgment to that debt would be 2%. Obviously, consumer debt transactions trigger in the mind things like credit card debt, and certainly this would apply for that. And the intent here of the legislature was to be of assistance to consumers. And they have a definition of what consumer debt is that is within the scope of the statute. And part of that definition involves debt that is incurred primarily for personal, family, or household purposes. So the question that is now percolating is whether or not a mortgage note, a note and mortgage, the note in particular, is a consumer debt within the scope of the statute, and whether or not foreclosure judgments are subject to 2% interest as opposed to a higher amount. Bruce Bergman, who was once a panelist for this very CLE 6 or 7 years ago, had an article that was published in the New York Law Journal back in 2022 after this amendment went into effect. It is his opinion, I'm not saying whether I agree with it or not, but it is his opinion that a judgment of foreclosure and sale isn't a money judgment that would fall within the scope of this 2% provision, but is instead a judgment in equity, seeking to sell the property and equitably divest the mortgagor of not only the title, but any proceeds that are realized from it. Yet I also had been told that subsequent to that some banks were simply playing it safe, and they were submitting judgments with the 2% interest instead of the 9% interest, rather than fighting it or trying to get away with the 9%. The opposite side of this issue, contrary to Bruce Bergman, is the plain language of the statute, which applies to 2%. Debts involving family or household purposes. Well, what's more basic to family and household purposes than the house and the cost of the house? And we also don't know, there being 62 counties in the state of New York, how 62 different clerks are going to interpret and apply this statute as well. So this does seem to be an area which is going to have to be sorted out. And as we've said before this evening, the words "stay tuned."
So we're gonna
Sorry, before
Go ahead,
we
Derek.
get to that, David, and we do have a little bit of extra time. So
Yep.
I just wanted to mention that Bruce Bergman may have a point about judgments of foreclosure and sale, but a deficiency judgment, and I actually have dealt with a deficiency judgment, is a money judgment. I don't think there can be any quarrel about that. And this definition of consumer debt involving family or household purposes almost completely, identically tracks the definition of home loan, which is what governs residential mortgages. So I would argue that in the case of a deficiency judgment, for a home loan, the 2% interest rate would apply, and to the extent that a judgment of foreclosure and sale was not, for instance, in the case that I was dealing with, the house was not sold until 2023, but the judgment of foreclosure and sale was in 2020. My argument was that the 2% interest, because none of the judgment of foreclosure and sale had been sold as of the effective date on April 30th, 2022, that the 2% applies to the entire deficiency judgment.
Derek and Suzanne, what has been your experience in terms of the 2% versus the 9%?
I will say that because borrowers have a right to redeem up until the sale, you have to know how much they have to pay to redeem, right?
Mm.
And so I would think, and the way I read the statute, I happen to agree with Derek that this tracks the language of a home loan and was certainly intended to apply in the residential mortgage foreclosure context, at least with respect to home loans. Perhaps, not necessarily all single family loans are home loans, but I think that is the better argument that 2% applies, and it doesn't, I haven't seen it come up, Mark, to answer your question, because in most cases the loans are underwater as to principal and advances anyway. And so the amount of interest is sort of irrelevant, since in many of these single family homes, the banks don't pursue, they don't have personal guarantees, and the deficiencies are not pursued, unlike in the commercial context.
I hadn't thought of it until now, but it also applies in surplus proceedings, because if the wrong rate of interest was charged, then there's less of a surplus.
That's true.
I really just thought of that, so I think that may be something that people might consider in the proper context.
Yeah, in the one case every year where it has a surplus.
Well, no, in Rockland County we get a few more than that. So, yeah.
So we'd like to end knowing that this isn't the end, but really just the prelude for next year, with a not so hypothetical. At the intersection of FAPA and of all things a legal malpractice action, because who doesn't want to end a 3-hour residential foreclosure CLE with a legal malpractice case? The moral of this story is going to be that FAPA issues can pop up in places we might not expect them. And depending on how much time we have, perhaps we can talk a little bit about, best arguments on either side. This is an actual case where the facts are changed enough so that we can't identify the case or the county. And the timeline is right there. So there's an action that is brought on a note in 2007 alleging a 2006 default on the loan. Fine. A new buyer for the loan comes in, purchases the mortgage on the secondary market. These things get collateralized. These things get traded around, and they substitute in as a new plaintiff. 2012, these things took especially a lot of time back in that era. Action number 1 is dismissed. The buyer's attorney fails to appear at a calendar call. We just saw 20227 operating on exactly that kind of basis. The buyer plaintiff moves to vacate the dismissal. Supreme Court says no thank you. Appellate Division affirms the denial of vacatur in 2015. And it looks like everything is done. Nope. Buyer turns around, hires a new attorney, starts another action. And this time the borrower moves to dismiss on limitations grounds. And the attorney files, this is the potential malpractice, an affirmation that action number one's plaintiff never held the note. They weren't a proper plaintiff, therefore they didn't have standing, therefore it didn't properly accelerate the debt. And Supreme Court says what hopefully we would now expect Supreme Court to say. As Suzanne was talking about earlier, the Bank of New York Mellon versus Gordon, it's not the foundational affidavit. It's certainly not the attorney affirmation. You actually need the evidence. It is the business record that is proof of the matter asserted. Supreme Court says, sorry, the mere attorney affirmation isn't enough. And so the Supreme Court dismisses the second action because by simply putting out an attorney affirmation, there was not raised a triable question of fact as to the standing of the first action's plaintiff. The appellate division affirms the dismissal. The buyer plaintiff is now in the difficult position of having to pay the borrower's attorneys reciprocal fees. I think it was in this case over $60,000 under Real Property Law 282. But wait, there's more. Now the buyer, upset with the attorney, goes ahead and sues for legal malpractice. And there were a couple grounds for the malpractice, but the basic gist for this purpose is, why did you put in a mere affirmation? Why didn't you get, an aff from the original action one plaintiff? Why didn't you get the note? Why didn't you put in a business record? That's just bad lawyering. So the buyer sues the attorney. And with that action pending, FAPA takes effect. In December of 2022, the attorney now moves to dismiss the action. Now, before FAPA, there probably wouldn't be much of an argument about the timeliness of action number 2. Or would there, at least to the extent of installment payments that were due 6 years or less prior to commencement? Without calling on Judge Dillon, how about under FAPA? Now that we have FAPA, what happens to this action? May I ask my panel? Oh, go ahead.
I could the legal malpractice actions are, we use the phrase in the case law, it's a case within a case. In order for the client to be a plaintiff in the legal malpractice case, the client has to be able to show that that was a viable, compensable case, but for the professional negligence of the attorney. And I think an argument can be made that if action number 2, the foreclosure action number 2 is untimely because you're retroactively applying FAPA, then there is no viable case. The malpractice of the attorney in action number 2 doesn't matter, because no matter what the status or quality or lack of quality of that affirmation is, action number 2 was not viable.
But it was viable at the time that the malpractice action was commenced.
But should it matter if we're now ahead in time and there's a motion to dismiss the malpractice action based on currently existing law that's being retroactively applied?
Which means that FAPA arguably... Go ahead.
Yeah, wouldn't mind my adding, in any legal malpractice action arising out of a mortgage foreclosure case, whether or not that mortgage foreclosure case that's underlying the legal malpractice action is viable will bring into the legal malpractice action all the issues that we talk about: standing, RPAPL 1304, FAPA, etc. So there's really no escaping the law of residential mortgage foreclosure when you have legal malpractice actions arising out of them.
And if Judge Dillon, your argument is correct, then arguably it follows that FAPA took away a clause of action that appeared extant on, it was a viable malpractice action in 2021, and now it isn't a viable malpractice action, and that could raise constitutional issues. And then we get back to the question of whether the claim vested. And if you go back to the Gleason case that Derek was talking about, sounds like maybe the legal malpractice claim didn't vest because they didn't have a right to the money. And therefore, FAPA arguably could take away the legal malpractice claim without running afoul of the Constitution. This gets messy. Derek, Suzanne, any thoughts on this? Because who doesn't want to end a 3-hour tour with legal malpractice?
By the way, while we're ending this with legal malpractice, there is not an ethics credit to the program. There are practice credits.
And just to make sure that you all get it, I'll get your practice credits while you're thinking, the rest of the panel's thinking about it. Here's the fourth code, which is Notary. Notary. The fourth code is Notary.
I believe there's a question in the chat if we're ready for that.
How about if, Ben, instead of telling everybody to read it, do you want to ask it?
Sure. So the bank obtains an order pre-FAPA from the second department, say, just hypothetically, saying that this is post-Engel, that the trial court erred in holding that the deacceleration notice was improper, and therefore the case was not timely. Second department overrules that. Then, because of Kessler, the case gets dismissed again. Then FAPA comes along. This case was originally filed in 2011, let's say. So naturally, when they refiled, the defendant goes to move under FAPA to dismiss, but the bank says, oh, no. The second department ruled in this case that the case was timely filed. The 2011 case was timely filed and remains timely filed. So res judicata, you have no FAPA claim.
So I have a question here, which is a decision from the appellate division is not a judgment. So I don't know whether I don't think that that an appellate division decision necessarily has preclusive effect. And you said in your question that the that case after let me just make sure, after it was remanded to the trial court, it was then dismissed. Is that right? So was there any order that held that has the preclusive effect of a judgment that where res judicata would apply?
Let's say there was.
Good question.
Does the retroactive effect of FAPA wipe the second department's ruling away?
Well, the judgment hadn't been enforced yet,
Right.
so it would apply, I think.
So FAPA would wipe it away. It does not have preclusive effect.
Well, I think Derek's right. There's no judgment. It could have collateral estoppel effect. I think you can have collateral estoppel effect just with an order. I don't think you need a judgment.
Right.
Um,
I think you know, I actually was just looking online for this. I think that for collateral estoppel, if there's a change in the law, a collateral estoppel does not apply. But res judicata may. So yeah, you really have to do some delving into these preclusive doctrines.
Yeah, okay.
And I mean, it's also law of the case, which is, I guess, discretionary, but that might mean it has to go back up to the second department to make that decision.
But it's a second case, so it's not law of the case. Because once the
Well,
case
you're
is
right.
dismissed, right?
Well, law of the loan, how about that?
I'll be interested to see that in an appellate division decision.
Only establishing for everybody that as these programs have continued every year, the issues have gotten that much more thorny. And that's why we keep coming back. And that's how the group came up with the title, that the complexities continue, because it just, this practice area of the law, everybody, just has simply not gotten easier to work in. If anything, it's just gotten that much more thorny for all of us to have to work every single case, you know, out there. With that being, so Ben, we're sorry, we can't give you anything better this year. So that means you've got to show up next year. But with that, we're going to go around to everybody and ask all of our panelists, okay, one by one, closing thoughts. Okay, we can start with Derek because he's on my big screen over here somehow. So Derek, closing thoughts. What do we want everybody to walk away with this year?
I would want people to walk away with the two things. I want people to walk away with the idea that of vested rights, and really examining whether there's a vested right if a plaintiff claims that retroactive application of FAPA is unconstitutional. And also walking away with the idea of being able to litigate standing where where there's at least an arguable claim that the note is non-negotiable because it's a cash account, or because the note itself says that the amount due is the amount that has been
Advanced, right.
what was that? I'm sorry.
The amount due is the amount advanced.
Advanced.
Right.
Thank you. That's the word I was looking for.
Yeah.
All right, then, Suzanne, closing
Well,
remarks. What do you want us to walk away with?
that lenders should not delay. There is all these complexities that we've talked about today arise because some cases are six years old or longer. And so I think lenders need to act with alacrity. I know that a lot of the legislative intent wanted to allow time to work things through and try to pause and try to wait till, you know, maybe there was a right to reinstate, but because there's so many dangers and traps in waiting in litigation, I think, you know, you have to try to move through as quickly as possible. And that might be counterintuitive to the legislative intent, but it's the only way to avoid all the complexities, or most of them, that we've talked about today.
All right,
Or
David?
modify. I mean, you know, or modify or resolve the loan or take a short payoff or do something like that. But
All right, moving on to David. David, what do you want everybody to walk away with?
The professionalism that, to whatever extent this area of law might ever have been amenable to some measure of automatic pilot practice. We know what the standards are for standing. We know what the business records exception is. The law and its complexity has gotten such that we need to resist the temptation to cut and paste. We need to resist the temptation to go on automatic pilot. These calculations of time and issues of standing and retroactive applications of statutes in ways that maybe the legislature didn't intend, but is the law. Every single case really has to be thought through very carefully in ways that maybe might not have been the ken some years ago. Now, whether the legislature will come and clean some of this up or the courts will come and clean some of this up, we don't know. So especially in this gray zone, good lawyering is going to be all the more important. And I know the courts will really appreciate high quality papers.
Okay. And how about the view from the appellate division? Judge Dillon.
I will just briefly comment on a comment that was left in the chat by Bill about CPLR 5004 and the consumer debt transaction interest of 2%. The statute does provide that if you had some or all of a judgment paid at the 9% rate when this law went into effect, the payer does not get a rebate of the difference between 9 and 2%. But going to his comment, if you have a portion of a debt or a debt that's unpaid when this law goes into effect, then is it 9% based on the what was awarded at the time the judgment was issued, or is there a 2% retroactivity now that you have to go back and calculate? And according to Bill's comment, that's being litigated as we speak in the federal courts. It's another example of a retroactivity issue that courts are grappling with here.
Well, can I say something?
Sure.
There's a federal judge in in New York that had determined it was an unconstitutional taking. She issued a stay, but only at the plaintiff who brought the action didn't really bring it properly. So the stay only pertained to 2 or 3 counties. Now the stay is no longer there, but the underlying merits of the case are still being litigated. But a lot of the collection attorneys in New York State have just accepted this 2% retroactivity, which caused a major problem with the enforcement officers and the sheriffs and so forth. But it's very possible that the federal court could end up throwing out the 2% retroactive aspect, and that's going to cause even more chaos. So I think my main comment about all this is the legislature didn't really think this thing through right and caused a lot of, this really has nothing to do with foreclosures that much, but I'm just commenting on the law. Thank you for acknowledging the comment.
All right. With that, Barbara, do you have anything to add if you're still there with us from the Bar
I'm here.
Association? Okay.
I'm here. No, the only thing is to just please remember to send in your the attendance affirmation, send in the evaluation. The CLE committee does read all the comments on the evaluations, and they're important for not only evaluating this program, but deciding what other types of programs to have. So send that in. And then be patient with getting your certificate back, because I have to do each one individually. So it might take a little while, a week or so. So thank you all for coming. And that's it from my side. Go ahead.
Okay, very good then. Yeah, the CLE committee, everybody, continues to just remain active. We're meeting every month. We're coming up with programs. So we're putting a lot of pressure on Barbara to do a lot of that background work for us every month. Patience with Barbara, much appreciated. She keeps all of us moving forward. She's already told you we got programs going forward. If you're here and you have a program that you think the Bar Association Continuing Legal Education Committee should take on, we always welcome any new ideas. Sometimes we just get trapped into the same programs because we're not getting new people coming in and saying, I'm willing to help out with my practice area and put a program together for everybody. So if you're listening in and you have a program, feel free to reach out to Barbara with an outline as to what you might want to present, and the committee will take it up and consider it. Before we go, I want to just say a shout out to Stanley Weiner, who I think is here tonight, and he was the chair of the Rockland County Bar Association's CLE committee for many years. So shout out to him. Shout out to retired Judge Alfred Weiner, who's also came to watch us tonight. We thank all of the rest of you for coming. The program is going to come back next year. We'll try to come up with a really cool title again next year when we're in committee. And in the immortal words of John McLaughlin, until next year, bye-bye.
Thank you all. Thank you to all the presenters. Good night.
Good night.